The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separations of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. The Society seeks to both promote awareness of these principles and further their application through its activities like today's debate. And so without any further delay, I'm going to turn over the event to our moderator, Dean Kalodner. Thank you.
Hey, thanks. Good. You know, I'm connecting the face with the name now. Good to see you again.
He's a groupie.
Yeah. Yeah. How are you, Howard?
I'm fine, Harry.
Good. Let me go over on this side.
Okay, thanks.
Yeah.
Good afternoon. Our topic for this presentation is, do we trust judges too much? Did the framers? Our speakers are Professor David Forte, who's sitting on my left, and Professor Bruce Miller, sitting on my right. Each will have 15 minutes for their presentation, and that's my principal job, is to see if I can keep everybody within that time. And so I have one nice sign that says time's up, and then, if it's necessary, one that says stop talking.
What terrible
I will not have to use that.
What a terrible sign to have.
After each presentation, after the presentations are over, I hope that there will be time for your questions, and I will recognize the persons with questions, and I hope you'll speak up so that you can be heard by everyone, and there'll be adequate time for answers and further questions as we go. We're planning on completing our hour by 1 o'clock. Professor Forte is on the faculty of Cleveland State University School of Law. He's a graduate of Harvard College, Manchester University, the University of Toronto, and Columbia University School of Law. He writes and speaks nationally and internationally on constitutional law, religious liberty, Islamic law, the rights of families, and international affairs. Professor Forte served as Chief Counsel to the United States Delegation to the United Nations and alternative delegate to the Security Council during the Reagan administration. He has testified before the United States Congress, consulted with the Department of State, testified before state legislatures in Ohio and Idaho, assisted in drafting a number of pieces of legislation. He has sat as an acting municipal judge, and he has served as chairman of the Professional Ethics Committee of the Cleveland Bar Association. He's received numerous awards and served as a visiting scholar at the Heritage Foundation, the Liberty Fund, and the Witherspoon Institute. He's also an accomplished author and editor. A small sampling of his publications includes serving as the editor of the Heritage Guide to the Constitution, a clause-by-clause analysis of the U.S. Constitution, and the author of Islamic Law Studies, Classical and Contemporary Applications. Indeed, it's hard to find anything that Professor Forte has not done. He has even found time in his busy career to be a Civil War reenactor and a merit badge counselor for the Boy Scouts. Professor Miller has been a member of the faculty of Western New England College School of Law since 1980.
Way shorter list.
He's a graduate of Stanford University and the Harvard Law School. Prior to joining our faculty, he served on the staff of the National Senior Citizens Law Center in Los Angeles, specializing in Social Security and private pension litigation in the federal courts. He has also served as an attorney with the United States Department of Health, Education, and Welfare. He teaches constitutional law and other public law and litigation-related subjects. His primary areas of interest focus on the challenges to the rule of law that have emerged as a result of the attacks of September 11, 2001, and on legal issues that especially affect poor people. He's president of No More Guantanamos, a nonprofit advocacy group, and he serves on the board of the Rosenberg Fund for Children. Join me in welcoming Professor Forte and Professor Miller. And our first speaker will be Professor Forte.
Thank you. Thank you. You understand that the length of introductions are in inverse proportion to the quality of the speaker. Someday, I'm hoping that you'll be able to say, he needs no introduction. But unfortunately, not that yet. This is good comfort food, isn't it, before the clock begins running? Because I have a John Marshall story to tell you before the clock begins running, which this weather reminds me of. Maybe you've heard it, but John Marshall was a very commodious and magnanimous host. And the justices of the Supreme Court in Washington would room together when they would have judicial meetings. He would liberally serve Madeira, his favorite beverage, until one day one associate justice said, you know, perhaps, Chief, you shouldn't be serving it during judicial conference while we're discussing cases. So they agreed that they would only serve it during rainy days. This would have been a great day for Justice Marshall. Unfortunately, Washington had one of its long summers that year, and finally, after a number of weeks, Justice Marshall went to the window and said, gentlemen, it has to be raining somewhere in our jurisdiction. So they began the comfort food again. Well, let me tell you, and now let me begin my talk to you. We've had another justice just confirmed into the Supreme Court. And you notice, and it's probably now become sort of part of your political environment, that one of the reasons why we elect presidents is because of whom he or she may appoint to the Supreme Court. It's just a strange development in our constitutional structure. Our presidents have become electors. Electors of the kinds of groups of people who will actually make policy over us. That is very strange. And in fact, that sort of thing was predicted by the anti-federalists who opposed the Constitution. The anti-federalist who went by the nom de plume of Brutus wrote in 1787, just before the New York Ratifying Convention, he said, those who are to be vested with the judicial power are to be placed in a situation altogether unprecedented in a free country. And he was right. They are to be rendered totally independent, both of the people and the legislature. And because they are in such an unchecked position, they will naturally aggrandize power to themselves and to the central government. This power will enable them to mold the government into almost any shape that they please. Some of you in your undergraduate education or here may have come across Hamilton's very famous argument for judicial review and defense of the courts in Federalist number 78. Well, he wrote that in response to Brutus. He didn't just write that off his head. He wrote it in response to Brutus, saying, you don't understand, Brutus, that these courts are going to act differently. They're not political actors in the normal sense of the word. And Hamilton famously in that Federalist number 78 said that the legislature is empowered with will, the executive with force, but the judiciary with judgment. So, and so he agreed that the judiciary should be unchecked. What does unchecked means? Independent. What does that mean? Not within the checks and balances on the rest of the government. They are free to do what they will for the most part. The checks are very minimal on the Supreme Court justices. Did Hamilton reflect what the framers thought the court should be? Absolutely. I go back to the documents about the framing. They wanted the courts to be independent. It was part of the one of the arguments against King George in the Declaration of Independence. Why did they think so? They thought so for two reasons. Number one, they believed their experience with courts. They were an extremely litigious group. They were in court all the time, the elites of the founding period. And yet, if you go through the records, they win and they lose, you never see somebody blaming the judge. They had a culture of judging that they experienced, which they could count upon to be neutral until the king started appointing his own judges, which were not independent of the king, and they did political acts at the behest of the king. So when Hamilton said the legislature is empowered with will, what the framers said is that that's a moral danger. A moral danger. It's in the nature of man that will could be put into law, so let's split the legislature. Let's leave it with limited powers. The executive, Hamilton said, is to be invested with force. And the framers said, yeah, that's what the king was. That's why we have to check the executive, make sure the legislature can check the executive. But then he said, the courts are to be invested with judgment. And what he meant there was that there was a sense of public virtue. Those are the words that they used. Virtue that goes with judging, that's not present in the manner in which decisions are reached by the executive or by the legislature. What is this judicial virtue? Well, it's by training. It's by temperament. It's by having, as St. Thomas Aquinas said, an inclination to justice that's been socialized into the work. It's the manner in which they reach decisions. Judges are supposed to retire from the case and deliberate. Legislatures argue. Judges deliberate. That's a rational process that Aristotle talked about as being essential to make a virtuous act. Deliberation before you act. And all these men read Aristotle. They didn't read Aquinas, but they read some of the people who read Aquinas. It's a more internal way of making decisions. It relies upon character. And they could trust the judges to do that. And within the whole judicial process, we have had a structure of judging, which all of you are familiar with, which become part of the pores and the skin and the flesh and the tissue of our lawyerly bodies. A respect for statutes and statutory interpretation. A respect for precedent. A respect for judicial process. All of these constrain the judgment of the judge in a way that they do not constrain a legislature. Res judicata, judicial ethics. Most importantly, reason and accountability. Judges have to give reasons, appellate judges, for their decisions. When you think about it, that's quite an astounding institution in our system. They just can't say, I got the majority, therefore I win. They have to give reasons to justify to those who are educated to read those reasons that they are acting neutrally and in a principled way. So, if you look at, for example, Chief Justice Marshall's opinions, they are the perfect type of opinion that looks at intention of the framers, that analyzes words, context, constitutional structure, history, all constraining his decision so it is justified in terms of reason. But Brutus was proved wrong in the 19th century. Judges did not act the way he had predicted. Yet today in the Supreme Court, we have a different view of what judges do. They seem to make national policy, whether the national policy is gun control, abortion, gay marriage, national policy that changes our lives, changes the whole country, changes the whole culture. They don't seem to have the same limitations. How did they get there? Well, there was a large movement in the late 19th century, ripening in the early 20th century, into a movement called legal realism. And what the legal realists said was, and I'm really painting with a broad brush, but I'm not painting inaccurately. What they said was, you know, judges actually make law with their decisions. Duh, yeah, of course, their decisions have the force of law. They change the way duties and obligations are. And the mistake the legal realists say that, because the effect of a judge's decision is to make law, the manner in which he makes the decision doesn't matter. But that's the key. The manner in which a judge makes decision is to be based, according to the framers, on the virtue of judgment, respecting statutes, constraining reason, respecting the other actions of government. But the legal realists thought that decision-making was fungible. Because the legislature makes decisions based on will, judges can too. And so this moral change occurred in the academy, in the law schools, among the professors, then their students, and then their students became judges. Namely, that it was okay to use will as a method of reaching a decision rather than judgment. Now, originally, when the Roosevelt Legal Realist Court came to power in 1938 and Ford, they thought that politics was will, but they deferred the will to the legislature. They no longer limited Congress in terms of will. The real change came in the Warren Court and the Burger Court, where will became the action of the judges themselves. That was true until 1985, when Attorney General Meese says it is time to return to a jurisprudence of original intention. The key to constrain a judge at the highest level is respect for the law of the Constitution. If he doesn't respect the law of the Constitution, he doesn't respect the very document that gives him power. But if you have a jurisprudence of will, your will can be neglectful of the Constitution. And thus we had all these opinions coming down in the 60s, 70s, and 80s, changing the nature and the way we lived, because judges now felt themselves empowered, morally empowered, to make decisions based on will, rather in their constrained notion of judicial virtue. So when Attorney General Meese said we must return to a jurisprudence of original intention, he wasn't just saying we need a different interpretive method of finding the right answers when we have a constitutional question. He wasn't just saying look at the Constitution, not just precedents, not just current theories of what the good life is, but what the framers said. He wasn't just saying that. He was saying return to a notion of what judicial virtue is. Constrain yourself in terms of what judicial virtue is. And he had a lot going for him. Because since the 1980s, there has been more research done on the original understanding of the Constitution by the framers than any time in our history. I am not exaggerating to say that we now know more. I probably know more than any justice in the Supreme Court after the time of Chief Justice Marshall of the founding generation as to what the original understanding was, because I'm reading all the research that's been unearthed about what the original understanding was. Judges who are not trained in history now receive the best history education in their briefs. You should have seen the briefs that went in the McDonald versus Chicago case, the gun rights control case. They were by the best historians who studied this in the world, from Great Britain to here, about the tradition of gun control and the tradition of self-defense in both cultures. Both opinions, the majority and the minority, are chock full of history as to what the original understanding truly was. So original understanding becomes not only morally an aspect of judging once again, it becomes practically an aspect of judging. Originalism is a real form of interpretation because the data is there now. It's not what they think the judges might have thought, the framers might have thought in 1787. They now have hard evidence. Judges now have the opportunity to be judges again. They now have the opportunity to earn our trust. We now can say, Brutus, you've been right for 50 years, but maybe it's now time that you are wrong, and we can go back to the vision of Hamilton and the framers, where a judge could be worthily trusted to reach his decisions on the basis of judgment. Thank you. How much time was that?
12 and a half minutes.
12 and a half.
Yeah, you came in quick. You came in quick. I have never yet once come in quick.
Oh my God, that's not fair.
Howard's going to have work to do now.
That's not fair. I got to take notes.
Okay, good. So it's good to see everybody. This is the second day in a row for me here, and there are more of you. Yesterday we had a Legislative Institute event, and today we have this, and there are more of you here today than were here yesterday, and I assume that has nothing to do with the fact that the Federalist Society can always offer really good food and that the Institute never can. It's good. One interesting thing about Chief Justice Marshall and the Madeira, I now feel like I know for sure why it is that William Marbury didn't get his commission delivered on time, and I think it was all of that Madeira that was being consumed in Marshall's office on the last night before the inauguration in March of 1801. I actually don't have much to disagree about with Professor Forte's really eloquent account of how judicial review ought to work. And you know, as is often the case, I begin to wonder, well, why am I here? Since I don't really disagree with him. In fact, much of what he said, it seems to me, is essential not only to judicial review, but to law, where I think we probably part company, and I know we part company on a lot of different cases, is with respect to how helpful it is when the going gets tough to do what Professor Forte says judges ought to do. It's essential, but I think it's the beginning. It's the beginning. Let me try to elaborate a little bit. First, the legitimacy of judging, the legitimacy of it for all of us has to depend on a distinction between law and politics. If all the judges do is exercise their political will, we have no reason to invest them with the power that they have under Article 3 to decide cases and controversies, because their politics are no better and no worse than our politics are. And if what you might call the progressive legal tradition depends in any way on this idea that what judges get to do or ought to do or may do is to simply, in the guise of law, express their political judgments, we ought to give up. We ought to give up the whole idea. There's no reason for them. And the distinction between law and politics, and here I agree with you also, depends crucially on the distinction between judgment and will that Hamilton drew in Federalist 78. Judgment is what we expect of judges. Will is something that, the nature of the human condition. And we try to constrain it through channeling it through democratic political institutions, but will is politics. And in Professor Forte's essay, on which his talk is based, which he kindly forwarded to me yesterday, he acknowledges something else that I think is very important, and that is that the exercise of judgment is not easy. It's not easy. It's really hard. And the last thing it is mechanical. In fact, if it were mechanical, if law or deciding what law was were in any way mechanical, why would we have 3 years of law school for you guys to figure out how to be lawyers? Why would we, in our teaching, emphasize endlessly the hard cases, the indeterminacy? And this is because, not that judgment is impossible, but rather, even more cussedly, it's difficult. But everything depends on it. And so you can see we have a broad range of agreement. One last point that we agree on is that the culture of argument is crucial. The fact that judges have to not just decide cases, but explain why and how they did it, and put their explanations up for, well, what you might call the most important kind of peer review there is, the review of lawyers, the review of other judges, the review of their informed fellow citizens, is essential to the discipline required to exercise judgment. Now here comes the disagreements, or at least the modifications or something like that. In my opinion, there aren't very many judges who would disagree with this on any side of the spectrum. When Justice Breyer was here 2 weeks ago, he said politics has nothing to do with what we do. Well, I mean, it sounded a little naive to me. But from the internal point of view of being a judge, if you're in the game, if you are acting as a judge, you believe, not that you are determined by the legal materials, not that it's mechanical, but that you are doing law, not politics, that you are doing your best to wrestle with the often indeterminate, always complex sources of law that inform the decision that you must reach. The decision is simply the best that you can do with what you've got, but you can't claim for it anything more than that. This doesn't mean relativism is true. Everybody is trying their best to reach the right decision. The only judge I know who has given up the game is a conservative, Richard Posner, who has written that and spoken many, many times to the effect that inevitably all judges do is make policy. And I think he believes that. And most people from the external point of view, looking in on the judges at what they do, believe that that's the case too, because the judges' decisions so often seem to coincide with what we take to be their political views. And so in that respect, there is a deep and important political impact and political effect of what they do. But from an internal point of view, they don't think so. This to me means that it's very, very difficult to tell what is judgment and what is will. Posner, even though he waxes very irreverent in print and on the hustings, he doesn't write his opinions as expressions of will. He plays what I think he thinks is a game, but what you and I think is in fact real. That is, that there are some kinds of arguments that count and some kinds of arguments that don't count, difficult as it is to find the line. Now, what can we say more particularly about this problem of judgment and will? One example of judges who think they are exercising judgment is the plurality opinion in Casey against Planned Parenthood, in which the Roe against Wade abortion right is reaffirmed by a plurality opinion thought to be written by O'Connor, Kennedy, and Souter. And the entire method set forth for deciding that case appeals to Hamilton 78 and reasoned judgment. Does that mean that it is reasoned judgment? Maybe not. I think it is. Professor Forte would think not. Similarly, in the Heller case, this is a case in which it's absolutely true, the first gun control case, and the second one too, this is true of, where the exchange between the justices is all about originalism and what the originalist means. Does this mean that this is about reasoned judgment? Well, what I want to say is it claims to be, but from my angle of vision, and I'm one who takes seriously the preambulatory language of the Second Amendment, which refers to the militia, it feels to me that the majority opinion in Heller is policymaking dressed up as originalism. The point here is that anybody can talk the talk, and the fact that I recognize the Heller decision as policymaking rather than law is not to say that the judges who were in that majority didn't believe that what they were doing is in fact law. Now this is a mystery and a paradox, and this is where our work begins. How do we reconcile the internal point of view of judging, which I think is in very much good faith? Everybody believes that they are operating according to the legal materials, with the observations of political scientists to the effect that it's impossible. The legal realists were people who recognized this problem and succumbed to it. In my opinion, the legal realists were all critique and no program. That is, their argument wasn't that judges should make policy. It was rather that it was inevitable that they do make policy and that there is simply no other option. and it can't possibly be desirable to do what's impossible. Well, I think it's possible to exercise judgment rather than will, but it's difficult. I think the person, and here maybe this is occurring to me because Howard's here, and he may have something to say about this after we're done. Howard had the great good fortune to clerk for one of the preeminent legal realists, in my opinion, and that was Felix Frankfurter. Felix Frankfurter understood, probably better than all of us, what the stakes are here, and he recognized the grave difficulty of any sort of easy way of saying what the legal sources meant in hard cases, and the need for deference to political judgment. In my opinion, and I think probably not Howard's, Frankfurter ended up being crippled by his own insight, in the sense that he thought that his own ideas about what things ought to be were kind of illegitimate. And he was, for that reason, very, very deeply restrained in his assessment of what the other branches were doing, and maybe gave up more of the checking value that was essential. This wasn't, I think, because Felix Frankfurter suddenly became a conservative when he got on the Supreme Court. It's rather because he had very grave difficulty figuring out how you could make value judgments in the role of judging. Now, I think the need for value judgments in the role of judging is inevitable, even if you are an originalist. And maybe it's true we are all originalists now. Certainly, it's very, very hard to identify the values that underlie the Constitution without some reference to originalism. Without some reference, first to the text and secondly to originalism, we're all unhinged. We would simply be making it up as we go along. But those values are often, number one, so abstractly stated, say, for example, the Equal Protection Clause, or so indeterminate, that is, susceptible of being argued both ways, especially by able historians, i.e., the Second Amendment, or sometimes effectively silent about the issue at hand, that it is often impossible to get far enough by reference to originalism, so that there are inevitably other arrows in the quiver here. I recommend to you guys a book that's about 20 years old by a law professor named Phil Bobbitt, whose work you know well and whom I disagree with on almost everything. But Bobbitt says, it's more than just originalism in text. There are questions as well of what you might call structure. Are there implications in particular cases from the structure of the Constitution? In McCulloch, for example, that states can't tax a federal instrumentality, or that discrete and insular minorities need special representation because of their inability to form the alliances necessary to participate in a democracy. These structural ideas, I think, are part of the argument, and they derive from the Constitution. I think there are also prudential considerations inevitably. What can judges actually do and accomplish, and what can't they? I think these inevitably matter and should matter. The slippery slope matters because we're lawyers, and we always worry about the slippery slope. And ethics matter. And the reason why ethics matter is that even for originalists, there's arguments about substantive due process. Calder against Bull, for example, suggested that we may have natural rights. And of course, substantive due process is some kind of a constitutional effort to apply that notion. None of these things can be ruled out. So our big task is how to reconcile two things that we all experience. And that is, from an internal point of view as lawyers, we think law matters. When we do law, it always seems to us to matter. We always reach a judgment as to what the right or wrong legal decision is. Sometimes we feel like it's a tie, but very rarely. With our political assessment, as Professor Forte says, that, my God, this all seems so political and all seems to be based on what the judge's politics are. Thanks, I'm done.
Thank you,
We're going to allocate 5 minutes to Professor Forte for a response.
And 2.5 in the bank.
Say something about Frankfurter.
No. Professor Miller's always been a gentleman in all of my talks, and once again, he's advanced the discussion enormously. He's made two major points. I'll take one because we don't have time. The latter of his 2 points was, what does actually doing originalism entail? That's complex, really interesting, but let's put that off. The first point I'd like to talk to, and that is, what are judges now doing when they think they're reaching judgments? Are they using will or are they using judgment? So let me talk about that more specifically. First of all, there was for centuries and continued on after the Constitution a culture of judgment in the courts. It's a culture. The method of reaching decisions, the method of deliberating on decisions, stare decisis, all those mechanisms that we study is a culture of law that helps the rule of law maintain its coherence. That was contested in the late 19th century by the progressivist movement, who said that all politics is will, including judicial politics. And the only question is, how do you come out right, not how you get there. Once you do that, you're on the way to all kinds of problems politically, in terms of autocracy and totalitarianism in other cultures. In terms of this, it started to undermine the rule of law. So it was the legitimacy of will as the way to reach decisions that started to infect the court. But it came into a culture of judgment. How did the two mix? Well, you start with Oliver Wendell Holmes Jr. Oliver Wendell Holmes Jr. believed that there was no there. There really was no substantive value in the law, but there was the game of the law. There was the craft of the law. That was what people called law in the high tradition. And so he was so beautiful in the craft of it, but it didn't mean anything to him, except the dance. Not that the dance communicated anything beautiful, but it was just physically so wonderful to look at. After 1938, this is a repetition, but I think it bears, the judges who came to the court believed that judging was no longer legitimate qua judging, that it was a species of will. And so what they did was saying, look, the legislature has got more representation, let them do the willful things, we'll step back. And then beginning in the 50s and 60s, they started saying to themselves, again, I'm painting broadly, they started saying to themselves, well, why not us? Why can't we reach some judgments? Now, this is the kind of variations you have. There are those whom I assert will use the language of judging, the virtue of judging, the language of the virtue, to express their will. They are simply hypocrites. They're pretending to judge, and they're not. And I put the primary hypocrite in that as Justice Brennan. He's the one who started this, who manipulated decisions, left dicta, case after case, that he could call upon in later cases because he knew what was coming down the pack. There were those who simply made policy. At least they were honest. Justice Blackmun in Roe v. Wade. Justice Blackmun said, why is the right to terminate a pregnancy within the liberty interest? His words, we feel it is. That is not judgment. That is not reason. And then you have those who simply fool themselves, who think that they are using the language of virtue when they're actually, and they honestly fool themselves when they're actually being very subjective about their will, and that's Justice Stevens. You look at Justice Stevens' last opinion a couple of months ago in the McDonald case, the gun case. It's embarrassing. It's embarrassing. It's his valedictory. He goes all over the place, has no coherence, and Justice Scalia gives him no mercy. So what is the effect on this, even on good judges? Well, let me take a conservative opinion. This is what I'll conclude my response upon. And that is this gun control case that came down, McDonald versus Chicago. The evidence is unmistakable. It's not totally unequivocal. But the historians that have gone through this for the last 20 years, mostly liberal historians, make it almost unequivocal that by the time the 14th Amendment was passed, a fundamental right of American citizenship was the right to bear arms. Whatever the Second Amendment said, it was now contemporaneously interpreted as the right to bear arms, primarily focused on the right of blacks to defend themselves against being massacred by the southern states after the Civil War. There's there is reference after reference after reference to the situation of blacks being disarmed and killed by the southern states as contrary to their fundamental rights to bear arms as the basis of the 14th Amendment. Okay. I'll just conclude with this, Dean, if you don't mind. So what did the four-person plurality of Alito, Scalia, Roberts, and Kennedy say, as opposed to Thomas, who almost always says it honestly? They said, the evidence is unmistakable that under the Privileges or Immunities Clause, this should be a right to bear arms. However, for the last 50 years, we've used the Due Process Clause, and that's good enough for us. What? What? They simply said, on the basis of habit, that we've incorporated rights on the basis of the Due Process Clause, we'll say it goes there, and not historically what was met. Now, a true originalist who used reason, as Thomas did in this case, would have come out and said it. So that's the habit we have when we don't practice the virtue of judging the way it has, that even judges who want to be originalists wind up giving it the back of their hands. Thank you.
Professor Miller asked me if I'd say a word about Justice Frankfurter, for whom I clerked for a year. I think that at every step, I think that, as Professor Miller suggested, Frankfurter was torn between, on the one hand, what he believed was right, but on the other hand, what he believed was appropriate for the court to do. His grave concern, and his grave concern during the period of the Warren Court, was that the court would undo its ability earned over the years to speak in a way that would be accepted by the American people. That is, that they were not free ever to make decisions which they could not justify as being compelled to make as a result of the legal materials, whether it be statutory or constitutional, with which they had to work, which they had to apply to a particular situation. When I first went to work, we had a special term, a special argument before the regular term, so that it was in August or early September, not after the first Monday in October. And it was a case called Cooper versus Aaron. And the court was unanimous. It was a case, again, after the desegregation decision in Brown, and it was a state that was clearly defying the judgment of the Supreme Court of the United States in that case. And the court was unanimous in its decision. But he wrote a concurring opinion. And the concurring opinion was an appeal to everyone who read it to remember the importance in the United States of the rule of law, and to distinguish between things that were simply the will of individual men on the one hand and what the law required on the other. And I asked him why he was writing the concurrence when, in fact, the court was unanimous, and he had no real disagreement with the language of the court. It was a per curiam decision. He had no disagreement with the language of the per curiam decision. And he said, well, there are a lot of lawyers in the South, and I'm really writing this opinion to them to remind them all about the best traditions of the law and the role of our courts in the legal system. And I'm reminding them that defiance of that structure is dangerous. He was concerned. He was concerned about the Supreme Court working in too rapid a way to change the law. Even though he himself was a politically liberal individual and had certainly fought for the rights of minorities and continued to fight for them, he was at all times concerned about the relationship between the United States Supreme Court and all of the federal courts and the people of the United States, and their willingness to accept that what was being done by the court was being done by reason and by law. You know, the funny thing is we're all Aristotelians, except we have different views of what Aristotle really meant by public virtue. And so this is my last comment to both of these. But the fact is that unlike Plato, who took the position that ideas were unvarying and wanted to create a state which reflected those unvarying ideas, something which St. Thomas Aquinas was found much more appealing, Aristotle did not. For Aristotle, public virtue, which had to be ascertained somehow, was learned and was a culture, but he didn't say that it was unchanging. He didn't say that it was unvarying. He didn't say that it was always the same response, always the same virtue, always the same value. Quite far from that. And so the problem here is, in part, a problem of a structural role of the courts and what they should or should not do, and whether they've been operating correctly within those bounds. Frankfurter was concerned that the Warren Court's overturning of many prior decisions and invention of new rules would result in another court, Supreme Court, with succeeding justices taking the same attitude toward stare decisis as was shown in the Warren Court. That was his concern, and he said it over and over again privately to other members of the court. And I think that what we've seen then, frankly, is that Felix Frankfurter was absolutely right. And so what we're seeing now, dressed up as originalism, is still an attitude which says that stare decisis is less important. And we have a history now of judges who, in the process of their nomination, come and feel that the thing that they must say most definitively is that they really believe in stare decisis, when in fact, day to day, as I read their decisions, I have reason to doubt that they are as devoted to stare decisis as Felix Frankfurter was. And I cite the present Chief Justice of the Supreme Court of the United States, who seems to be much more like Earl Warren than he was like Felix Frankfurter in terms of his legal culture and his interest in judgment, as opposed to in the end results of the process of decision making. The result, the rule, rather than the methodology by which the rule is discovered and imposed.
Thank you.
Just my thought. Questions? Yes.
How can you say that the Supreme Court should not be the ones to make policy decisions when they're the only ones that can make unpopular decisions without being voted out
Question.
No, they should, their function is to make unpopular decisions as the Constitution has prevented legislatures from making those decisions. Let me explain. A Constitution is written to restrain us against ourselves. Constitution is not written to restrain other people. It's to restrain. That's why we use it, restrain it against ourselves. And the best example I can give you of this is the 14th Amendment. Who drafted the 14th Amendment and wrote it? White guys. Who ratified it? White guys. Against whom was it designed? White guys. The whole point is to restrain ourselves. So when a popular majority comes along, as in the late 19th century, and says we should deny equal protection to the blacks and segregate them, only Justice Harlan goes back to the original understanding of the 14th Amendment and says this popular view is not allowed under the Constitution. That does not legitimate the court from deciding that an area which is up to the legislature comes to the wrong decision. And although, you know, they may be more popular, we're going to impose our will anyway. You see what I mean? It's only if it's based in the Constitution. That's where you constrain the popular will. You don't constrain it because the judges happen to think that it's working out the wrong way. So if the right to an abortion or or any of the other rights that were posited is not in the Constitution, and if the restrictions on abortion, the moderating restrictions on abortion, were popularly enforced by the states, just because the justices think that was a wrong decision doesn't legitimate them in saying so. They have to tie it to the Constitution, honestly, coherently, and with real reasons. And that was not done, just giving you an example, in Roe v. Wade. She's got to follow up.
Yeah, fair enough.
But doesn't that continue the Federalists persecuting the weak minorities in the
Maybe.
Go ahead.
Let me try and, I agree with you. I think it does. And I agree with you further that it is part of the role of the Supreme Court to not always protect, but to be attentive to weak, disempowered political minorities, especially if there's reason to think that that weakness and disempowerment is permanent or lasts a long time rather than being evanescent. But to me, that isn't a question of policy. It is a question of law. And the reason for me why it's a question of law is that there are numerous provisions of the Constitution that I think are impossible to understand without reference to that value of protecting minorities. I am a believer, and I really don't know where you are on Caroline footnote 4, but the job of the court, as suggested by Chief Justice Stone in Caroline Products case, footnote 4 in the mid-1940s, explicitly is to protect the interests of discrete and insular minorities. His wording, not mine. To say that is not to get you results in any direct way in particular cases, because how discrete and insular do they have to be? What counts as a minority? But certainly, I think your idea has explanatory and justificatory force with respect to the Constitution, but not because it's good policy, but rather because it's law. The mystery in all of this to me, and Howard, you mentioned change. Change by judges is very paradoxical. How do judges accomplish change? Plessy to Brown. You know, Howard says it's not always the same. That the same language can mean different things at different times. I think he's right about that. How can that be true, though, especially under an originalist account of constitutional meaning? This is an interesting problem for us. If we had more time, we could do more with it.
And another problem, if the court decides to make change based on policy, is what the dean pointed out, but I think there's a bad side effect, and that is stare decisis. Stare decisis then becomes a ratchet. Plessy versus Ferguson was a precedent that Brown had to overcome. Brown overcame it appropriately because it was a bad decision to begin with. Not that it outlived its usefulness, that the court is making a decision, not that society had ripened and we now have new morals that the court thinks has to be put in place. It was bad originally under the law. And so when Chief Justice Roberts wants to undo some stare decisis, it's the ratchet. The Warren Court, which abused stare decisis to create new policies, doesn't seem to have, to me, to have the legitimacy to now say, out of the grave, stare decisis, now keep our policies, you're being disrespectful to stare decisis, when their original decisions may have been questionable. Thank you for those two questions.
Other questions?
Thank you.
I guess we're done.
Okay, we're done.
Okay, thanks.
Thank you.